Please be seated, everyone. The record should reflect that the jurors are now present in the courtroom. Welcome back, folks. How are you? Good. Thanks for coming back, and thanks for being on time. All 24 of you were on time today, and I very much appreciate that. The first thing I want to do is to take roll. I want to make sure that you're all seated in the seat where you're supposed to be. And so in the front row, I have from the seat closest to me 737, and then 706, 412, 267, 557, 307, 311, and 313. In the second row, I have in the seat closest to me 872, then 1009, 118, 983, 378, 155, 527, and 673. In the top row, I have in the seat closest to me 640, then 17, 329, 661, 535, 87, 901, and 495. Wonderful. Everyone is seated in the right place. Please try to keep those seats if you can throughout the proceedings, because it allows us to keep track of you when you're in the courtroom. There are a lot of you, 24, and so this is the way that we can keep track of who you are. Before we start, I want to let you know that I entered an order last week to further protect your privacy. I realize that this is a high-profile case, and I've mentioned before to you that your privacy is important to me. In addition to prohibiting the media from taking photographs and videotape of any of the jurors in this case, I have now also prohibited any members of the media from, number one, contacting or communicating with any jurors, their family members, friends, co-workers, and acquaintances. Number two, publicly identifying any juror. Number three, publicly providing any information that was not disclosed in court and that could reasonably lead to the identification of a juror. Number four, following or monitoring any juror, including while entering or exiting a courthouse parking lot, while entering or exiting the courthouse, and while in the courthouse. And number five, photographing, video recording, documenting, investigating, or researching a juror's license plate number or any other information that could reasonably lead to the discovery of a juror's contact information, home address, or work address. This order will be in effect until these proceedings are completed and applies to all 24 jurors, even after you have been discharged, if such discharge occurs before the completion of the proceedings. Obviously, once the proceedings are over and you are discharged, then the order is no longer in effect at that time. Does everybody understand that? All right, and everybody's nodding their head yes and saying yes. Thank you. As I mentioned a couple of weeks ago, the first step in the trial will be opening statements. The attorneys may make an opening statement if they choose to do so. Defense counsel may reserve opening statement until later in the trial, or they may decide not to make an opening statement at all. Remember that the defendant in a criminal trial does not have to do anything because he is presumed innocent, and that presumption of innocence remains with him and must be given effect by the jury throughout the trial. An opening statement is not evidence. Its purpose is to give you a framework or a roadmap to help you understand what evidence each party anticipates will be presented. Next, the prosecution will offer evidence. Evidence is what the witnesses say under oath in items that are admitted by the court as exhibits. You will hear throughout the proceedings the parties refer to exhibits, and it'll be their numbers or letter. And so it could be, for example, Exhibit 1, or it could be Exhibit A. You might hear Prosecution Exhibit number 1 or Defense Exhibit A. Just because an item is marked as an exhibit does not mean that it's evidence. Evidence refers to exhibits that are admitted, and I will make those decisions. And so you will hear that the attorneys will often say, Judge, we move for the admission of this exhibit. And then at that point, it's my determination in terms of whether the exhibit as marked should be admitted into evidence or not. Only if it's admitted does it then become evidence. I should tell you that there are some exhibits that are used for demonstrative purposes, and those are exhibits that the parties may be permitted by the court to use, not to admit them into evidence, but as demonstrative purposes, to demonstrate things to you here in the courtroom. And again, it's my decision as to whether I allow that or not. After the prosecution's evidence, the defense may present evidence, but is not required to do so. Again, that's because the defendant is presumed innocent and the burden of proof is entirely on the prosecution. The prosecution must prove the defendant guilty beyond a reasonable doubt. The defendant does not have to prove his innocence, call any witnesses, or introduce any evidence. After all the evidence has been presented, I will tell you the rules of law which you must use in reaching your verdict. These rules of law are called jury instructions. At the end of the trial, right before closing arguments, I will give each of you a copy of the jury instructions. I mentioned this to you a couple of weeks ago. I will then read the jury instructions to you verbatim here in the courtroom and will ask you to follow along on your copy as I read them. You will be allowed to take your copy of the jury instructions with you to the jury room during your deliberations. It is my job to decide what rules of law apply to the case. You must follow all of the rules as I explain them to you. You cannot follow some rules and ignore others. Even if you disagree or do not understand the reasons for some of the rules, you must follow them. You will then apply these rules to the facts that you have determined from the evidence. In this way, you will decide whether the prosecution has proven the guilt of the defendant beyond a reasonable doubt. After you've heard all the evidence and the jury instructions, the prosecution and the defense may make their closing arguments. Because the prosecution has the burden of proof, it will have the opportunity to reply to any closing argument made by the defense. So the prosecution goes first and goes last in closing arguments, and the reason for that is that the prosecution has the burden of proof. Like opening statements, closing arguments are not evidence. Their purpose is to give the lawyers an opportunity to remind you of the evidence that they believe was presented during the trial and to argue why you should return a verdict of not guilty by reason of insanity, or guilty. After the closing arguments, you will go to the jury room to deliberate on a verdict. Your role as jurors is to decide what the facts are, and your decision must be based only upon the evidence presented during the trial here in the courtroom. And so you will determine the facts. I will give you the law that you are then to apply to the facts as you determine them to be based on the evidence that's presented here in court. Let me talk to you about some things that are likely to come up during the trial now that I've given you sort of an outline of what a trial is like. At times during the trial, the attorneys may make objections. If an attorney makes an objection, it means that the attorney is asking me to decide a particular legal issue. It is proper for an attorney to object to things which he or she believes should not be presented as evidence. When an objection is made, I have two choices. I can disagree with the objection and overrule the objection, or I can agree with the objection and sustain the objection. If there is an objection to a question, and I disagree with the objection and overrule the objection, it means that the witness may answer the question. If I agree with an objection to a question and sustain the objection, it means that the witness may not answer the question. In the event that I sustain an objection to a question, you must not consider the question for any purpose or guess how the witness might have answered. Instead, you must disregard it and treat it as though you never heard the question. Similarly, to the extent that the witness had already started answering the question by the time the objection was made or by the time I sustained the objection, You must not consider the partial answer for any purpose. Instead, you must treat it as though you never heard it. The attorneys will do their best to object in a timely fashion, but as experienced and as skilled as attorneys may be, sometimes the witness will blurt out part of the answer before the objection is made or before I rule on the objection. In that event, you are to treat the partial answer as though you never heard it. You are to disregard it. If I overrule an objection to an exhibit as opposed to a question, it means that the exhibit will be allowed into evidence. If I sustain an objection to an exhibit, it means that the exhibit will not be allowed into evidence and you must not consider it for any purpose. Instead, you must treat it as though you never saw it. This goes back to what I mentioned earlier in terms of exhibits and me having the decision to either admit the exhibit or not admit the exhibit into evidence. Please do not concern yourselves with the reasons for my decisions about any objections. You must not let yourself be influenced in any way by the objections or by my rulings on the objections. As a judge, I do not have any opinion either for or against anyone involved in the case. Remember I mentioned to you a couple of weeks ago, I am neutral in these proceedings, and I think I mentioned that to many of you during individual questioning. The judge is neutral in the proceedings. You must not think that I have an opinion for anyone or against anyone based on any rulings that I make or anything that I say during the trial. You should also not keep track of the number of objections that I sustain and overrule for each party. For example, it would be improper for you to think, well, he has sustained 7 objections for this party, but only 2 for this party, so he must like this party better, or he must think that this party has a better case. That would be improper. I am doing my best to apply the law. That's all I'm doing. I don't have a position in terms of one side or the other. I am just applying the law to the best of my ability. During the course of the trial, I may ask a question of a witness. If I do, that does not indicate in any way that I have an opinion about the facts of the case. My questions are intended only to clarify the testimony. The answers that witnesses give to my questions are therefore of no greater value or weight than any other answer that may be given to a question that is asked by an attorney. At times, I may instruct you to disregard statements that you have already heard or things you have already seen. You must treat them as if you had never heard or seen them. You must not consider them for any purpose. I want to remind you that you will not have a transcript of any of the testimony at any point during the trial, including in your deliberations. Remember I mentioned that a couple of weeks ago? And I think I repeated it a couple of weeks ago. I'm repeating it again because people tend to forget. All right? Having said that, you will be able to take notes. You will receive notebooks later today that you may use to take notes during the trial. Because this trial is expected to take 4 or 5 months, you may find it useful to take some notes. Please understand, however, that you are not required to take notes. People want to know when they're on a jury whether they should take notes or not. And what I always tell jurors is that it depends on yourself, your personality, and who you are. And you know yourself best. And so I liken it to when you were back in school. Remember when we were all back in school, some people took a lot of notes, some people didn't take any notes. And so it's sort of the same way. You know what works best for you. I have to give you a cautionary instruction here. If you do take notes, you should not allow the note-taking to detract from your close attention to the testimony and the conduct of each witness and all other evidence received during the trial. The fear is that if you're so caught up in taking notes that you're looking down the whole time, you're going to miss what's happening here in court. You're going to miss the proceedings. And so if you take notes, make sure it does not detract from your close attention to the testimony and the conduct of each witness and all other evidence received during the trial. remember that as jurors, part of your role is to make credibility determinations of the witnesses who testify here. And I read the credibility instruction to you a couple of weeks ago. I'm going to read it to you again later today. But one of the factors that you have to look at, or some of the factors, have to do with visual observations here in the courtroom, which you will not be able to make if you're looking down the whole time and taking notes. Whether or not you take notes, you should rely on your memory as much as possible. The notes you take are to refresh your own memory. You should not give additional weight to the comment or comments of any juror based upon the quantity or quality of his or her note-taking. The notebooks that we're going to give you that allow you to take notes may only be used in the courtroom or in the jury room. Therefore, you may not take them anywhere else. You may not take them home. You may not take them to the cafeteria. You may not take them to your car. Don't take them anywhere else. There are only two places where you can have the notebooks, here and in the jury room. And we have 3 jury rooms for you because you're a large group. And so in any of those jury rooms would be okay. But those are the only places where the notebooks can be. To identify your notebook, please write your name on it when you receive it. You should know that no one else will read your notes. Even the attorneys and I will never read your notes. That's because we want to make sure that you feel comfortable writing whatever you want to write in your notebook. When the trial is over, my staff will go through the notebooks, they will yank out your notes, and they will destroy them without reading them and without ever showing them to the attorneys or me. So the attorneys and I will never get to see what notes you take. Those are destroyed at the end of the trial by my staff. While on the topic of notes, I may take notes at times during the trial. Please do not read anything into that. Do not draw any inferences from the fact that I may or may not be taking notes. There are reasons why I sometimes take notes and other times do not take notes. That's all right. And please remember to keep all your electronic devices off while you're in the courtroom. At least it was a good jingle, a good ring. And usually you'll have more time before you come in the courtroom, and you'll be able to put your things in the lockers. We've got lockers for you, and so usually that's what you would do before you come into the courtroom. That way you won't have any phones or electronic devices when you're in court. I was talking about note-taking and how sometimes I may take notes and sometimes I may not take notes. Just because I'm taking notes doesn't mean that something is important. Conversely, just because I'm not taking notes doesn't mean something is not important. There are different reasons why I take notes, and you should not read anything into that. Rules governing jury trials do not allow jurors to ask questions directly of a witness. I mentioned this briefly a couple of weeks ago. I have ruled in this case that jurors may ask questions of witnesses through me. If you have a question that you would like to ask a witness during the trial, please write your question down on one of the forms that we have included in your notebooks, but do not sign it or write your name on it. Then fold the form and pass it down to the juror sitting in the front row of the jury box in the seat closest to me, who is 737, and then that way he can put it down on the bar there in front of the jury box. At the end of a witness's testimony, when the witness is done testifying, I will look to that spot, and if I see that there are sheets of paper there, it will alert me to the fact that there may be questions from the jury. I think it's a good idea to wait until close to the end of a witness's testimony before submitting a question. If you submit a question within the first few minutes of a witness's testimony, let's say you write a question down, you fold the paper and you pass it down, you can do that if you want, but then one of the attorneys may cover that question. And so I think it's better to write the question down so it's not bothering you and so you're not concerned also about forgetting it. Write it down and hold on to it, and then wait until the end of the witness's testimony to pass it down. That way, if somebody asks the question that you've written down, you can just hold on to the sheet of paper. You don't have to pass it down. You don't have to pass down the form. Or if you have multiple questions on the form, you can cross one of the questions out and then pass the form at that point with the one question crossed out and the other questions remaining visible on the form. How will you know whether the witness's testimony is close to the end? It's hard to tell, but I think it's helpful if you have a brief understanding of what to expect in general. The party calling the witness conducts what we call direct examination. So the party that calls the witness gets to ask questions first. The opposing party then has an opportunity to conduct what we call cross-examination, to ask questions at that point. If there is cross-examination, then the party that called the witness may conduct redirect examination. And if there is redirect examination, then the opposing party may conduct re-cross-examination, and that's the end of it. Now, if there is no cross-examination, there can be no redirect examination. And if there is no redirect examination, there can be no re-cross-examination. Before a witness is permitted to leave, I will ask if any of the jurors has questions for the witness, and I will give you a minute or two in case you want to write questions at that point. So if you prefer to wait until the end of the testimony to write any questions down, you will have an opportunity to do that at the end of each witness's testimony. But like I said, you can also write it down and hold on to your form and wait to pass it down until the witness finishes testifying. Once the witness completes his or her testimony and leaves the courtroom, it is too late at that point to submit a question for that witness. So if you want to submit a question for me to consider asking of a witness, you have to do it before the witness is finished with the testimony and leaves the courtroom. Once the witness is released and leaves the courtroom, it's too late at that point to submit a question. By the way, if I forget to ask you if one of you has a question for a witness, please signal the bailiff or get my attention and let me know that you have a question and I forgot to ask you. I will discuss each question submitted by a juror with the attorneys outside your hearing. And so what we will do is I'll have counsel come up to the bench and we'll have a bench conference and I'll turn the white noise on so that you can't hear what we're saying here. Keep in mind, please, that if I decide that the question is proper, I will ask it. If I decide that the question is not proper, then I will not ask it. The rules of evidence or other rules of law may prevent some of the questions that you submit from being asked. I may also conclude, based on the rules of evidence or other rules of law, that I should modify one of your questions. I will apply the same legal standards to your questions as I do to the questions that are asked by the attorneys. By making legal rulings on the admissibility of your questions, I do not intend to suggest or express any opinion about the question. My decision whether or not to allow a question is based on the applicable rules of evidence and other rules of law and not on the facts of this particular case. It is my responsibility to assure that all parties receive a fair trial according to the law and the rules of evidence. If a particular question is not asked, please do not guess why or what the answer might have been. If I don't ask a proposed question, it is not a reflection on the juror proposing it, and you should not attach any significance to it. The fact that certain questions are asked must not affect your consideration of the evidence in any way. In other words, please do not give greater weight to questions or answers to questions that are submitted by yourself or your fellow jurors. In making decisions in this case, you must consider all the evidence that has been presented. Now, a couple of weeks ago, during group questioning, does everybody still remember group questioning? I know it's been a while. Yes, okay. I gave you some instructions of law. And since it's been a couple of weeks, I think it makes sense for me to go over some of them again. And so I will do that at this time. Please remember, folks, that I'm not expecting you to memorize these instructions right now. These instructions will be included among the final instructions at the end of the trial, and each of you will receive a copy of the complete set of instructions right before closing arguments. At this time, all I'm asking you to do is to listen to the instructions as I read them to you, to pay attention to them. First, The charges themselves are not evidence of anything. They are not proof that the defendant committed any crime. No juror should assume that the defendant committed a crime just because he has been charged with doing so. Every person charged with a crime is presumed innocent, and that presumption of innocence remains with him and must be given effect by the jury throughout the trial unless, after considering all of the evidence, the jury is then convinced that the defendant is guilty beyond a reasonable doubt. Because the defendant in a criminal trial is presumed to be innocent, the burden of proof is entirely on the prosecution. The prosecution has the burden of proving beyond a reasonable doubt each element of each crime charged. At the end of the trial, the jury will consider all of the evidence presented and will decide what has been proven by the evidence. Then, based on the law that I will explain in the jury instructions, the jury will decide whether the prosecution has proven beyond a reasonable doubt that the defendant is guilty of any of the crimes charged. I gave you the definition of reasonable doubt a couple of weeks ago. Let me give it to you again. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all the evidence or the lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. Again, the burden of proof is on the prosecution to prove each element of each crime charged beyond a reasonable doubt, and reasonable doubt is a doubt that is based upon reason and common sense that arises from a fair and rational consideration of all the evidence or the lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. A crime is committed when the defendant has committed a voluntary act prohibited by law together with a culpable state of mind. Voluntary act means an act performed consciously as a result of effort or determination, and includes the possession of property if the actor was aware of his physical possession or control thereof for a sufficient period to have been able to terminate it. Proof of the voluntary act alone is insufficient to prove that the defendant had the required state of mind. The culpable state of mind is as much an element of the crime as the act itself and must be proven beyond a reasonable doubt either by direct or circumstantial evidence. In this case, the culpable states of mind that are elements of the crimes charged are 1. After deliberation and with intent, and 2. Knowingly. After deliberation and with intent is the culpable state of mind element for the crimes of murder in the first degree after deliberation and with intent, and attempt to commit murder in the first degree after deliberation and with intent. Knowingly is the culpable state of mind element for the crimes of murder in the first degree extreme indifference, attempt to commit murder in the first degree extreme indifference, and possession of an explosive or incendiary device. The term after deliberation means not only intentionally, but also that the decision to commit the act has been made after the exercise of reflection and judgment concerning the act. An act committed after deliberation is never one which has been committed in a hasty or impulsive manner. A person acts intentionally or with intent when his conscious objective is to cause the specific result prescribed by the statute defining the offense. It is immaterial whether or not the result actually occurred. A person acts knowingly or willfully with respect to conduct or to a circumstance described by a statute defining an offense when he is aware that his conduct is of such nature or that such circumstance exists. A person acts knowingly or willfully with respect to a result of his conduct when he is aware that his conduct is practically certain to cause the result. As you know, Mr. Holmes has pled not guilty by reason of insanity, which includes the plea of not guilty. Under Colorado law, a person charged with certain crimes, including all of the crimes charged in this case, may plead not guilty by reason of insanity. By pleading not guilty by reason of insanity, the defendant says that he is not legally responsible for the offenses charged because he was insane at the time of the commission of the act. Under Colorado law, the defendant was insane at the time of the commission of the act if either 1, he was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act, or 2, he suffered from a condition of mind caused by a mental disease or defect that prevented him from forming a culpable mental state that is an element of a crime charged. But care should be taken not to confuse mental disease or defect with moral obliquity, mental depravity, or passion growing out of anger, revenge, hatred, or other motives and kindred evil conditions, because when an act is induced by any of these causes, the person is accountable to the law. In addition, diseased or defective in mind does not refer to an abnormality manifested only by repeated criminal or otherwise antisocial conduct. Mental disease or defect means only those severely abnormal mental conditions that grossly and demonstrably impair a person's perception or understanding of reality and that are not attributable to the voluntary ingestion of alcohol or any other psychoactive substance. Mental disease or defect does not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. As I mentioned earlier, folks, the defendant is presumed innocent, and that presumption of innocence remains with him and must be given effect by the jury throughout the trial. Therefore, the defendant does not have to prove that he was insane at the time of the commission of the act. Rather, the prosecution has the burden to prove beyond a reasonable doubt that the defendant was not insane at the time of the commission of the act. In order to meet this burden of proof, the prosecution must prove beyond a reasonable doubt both: 1, that the defendant was not so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act, and 2, that the defendant did not suffer from a condition of mind caused by a mental disease or defect that prevented him from forming a culpable mental state that is an element of a crime charge. At the end of the trial, the jury will decide whether the prosecution has proven beyond a reasonable doubt each element of each crime charged, including the additional element that the defendant was sane at the time of the commission of the act. If the jury finds that the prosecution proved beyond a reasonable doubt each element of a crime charged, including that Mr. Holmes was sane at the time of the commission of the act, then the jury must return a verdict of guilty on that charge. If the jury finds that the prosecution did not prove beyond a reasonable doubt each element of a crime charged, including that Mr. Holmes was sane at the time of the commission of the act, then the jury must return a verdict of not guilty on that charge. In the event of a not guilty verdict, the jury will be asked to specify whether it found Mr. Holmes not guilty on that charge based solely on the prosecution's failure to prove beyond a reasonable doubt that he was sane at the time of the commission of the act. If the jury concluded that the prosecution failed to prove beyond a reasonable doubt only one element of a crime charged, the element that Mr. Holmes was sane at the time of the crime charge, at the time of the commission of the act, then Mr. Holmes will be found not guilty by reason of insanity as to that charge. If the jury concluded that the prosecution failed to prove beyond a reasonable doubt any other element of a crime charged, Mr. Holmes will be found not guilty as to that charge. Accordingly, as to every crime charged in this case, Mr. Holmes may be found guilty, not guilty, or not guilty by reason of insanity. As I have mentioned, folks, the jury will determine the facts in this case. And then I will give you the instructions that you are to apply to those facts. A fact may be proven by either direct or circumstantial evidence. Under the law, both are acceptable ways to prove something. Neither is necessarily more reliable than the other. Direct evidence is based on first-hand observation of the fact in question. For example, a witness's testimony that she looked out a window and saw snow falling might be offered as direct evidence that it snowed. Circumstantial evidence is indirect. It is based on observations of related facts that may lead you to reach a conclusion about the fact in question. For example, a witness's testimony that she looked out a window and saw snow covering the ground might be offered as circumstantial evidence that it had snowed. In determining the facts in this case, you may have to decide what testimony to believe. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. Consider each witness's knowledge, motive, state of mind, demeanor, and manner while on the stand. Consider the witness's means of knowledge, ability to observe, and strength of memory. Consider also any relationship that each witness may have to either side of the case. The manner in which each witness might be affected by the verdict, and the extent to which, if at all, each witness is either supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence which affects the credibility of the witness's testimony. You may believe all of the testimony of a witness, or part of it, or none of it. Remember that the jury must decide this case based only on the evidence presented during the trial and the instructions of law that I provide. Whether the defendant is guilty, not guilty, or not guilty by reason of insanity must not be decided as a result of either sympathy or prejudice for or against the prosecution or the defendant. All jurors must conscientiously follow and apply all of the rules I give you during the trial, including the ones that I discussed just now and including the ones that I've given you before. Does everybody understand all that? All right, let me talk to you, and everybody's saying yes, and not in their head yes. All right, let me talk to you briefly about alternates. As you know, we have 12 alternates here. All 24 of you are jurors and will get to hear and see every part of the trial. You will all participate the same and will be treated equally throughout the trial. The only difference is that the alternate jurors will not get to deliberate at the end. Now, the parties, the attorneys and I know who the alternates are, but we're not allowed to tell you until the end of the trial, right before deliberations. And the reason for not telling you until right before deliberations is that we want all of you to pay attention and concentrate throughout the trial. The fear is that if we told you up front who the alternates are, that those individuals may be tempted to lose interest in the case or may fail to take the case as seriously as they should and to pay close attention to the proceedings. I want to apologize in advance to you for the alternate system. It's a lot to ask of citizens, not only to come here and participate in this process, but to then participate without getting to deliberate. That can be a difficult thing to take, especially in a trial which may last 4 or 5 months. So I apologize in advance, but it is something we have to do. And the reason for that is that the defendant in a criminal trial has a constitutional right to have 12 jurors decide his case. That is the constitutional minimum. And if we only selected 12 jurors and one of the 12 got sick or became unavailable for whatever reason and could not deliberate, we would have to stop and start the entire process all over again, beginning with selecting a new jury. And so in this case, we've selected 12 alternates because it's a trial that's expected to last several months or multiple months. At the end of the trial, when I announce who the alternates are, I will not excuse or discharge them. The reason is that if there happens to be a guilty verdict and a charge of first-degree murder, we will need to have a sentencing hearing, as you know, and I will need the alternates to continue as jurors in case one of the other jurors becomes unavailable during the sentencing hearing. What that means is that even though the remaining alternates did not get to deliberate on the question of guilt, one or more of them may get to deliberate if we have a sentencing hearing and if one of the other jurors becomes unavailable during that sentencing hearing. So The alternate will continue to be under the same obligations as all the other jurors in terms of complying with all my admonishments with respect to your conduct when you're not in the courtroom. And the reason for that is to preserve the option to allow us to use an alternate to replace a juror who becomes unavailable during a sentencing hearing if we have a sentencing hearing. Please remember also, folks, that just because we talk about potential sentencing hearing doesn't mean that Mr. Holmes will be or should be found guilty of anything. I've been over this multiple times with each of you in individual questioning. We have to plan for all contingencies. So don't infer from these comments that Mr. Holmes will be or should be found guilty of anything. I just needed to explain to you how the alternate system works. All right, folks, we're going to take a recess here pretty soon. I'm going to give you a summarized version of the admonishments that you have to observe during the break. I want to remind you that until the trial is completed, you must not discuss the case with anyone, either in person, using the internet, or by any other means. This includes members of your household, including your spouse, significant other, family members. This also includes friends, co-workers, acquaintances, people involved in the trial, other jurors, or anyone else. You also must not allow anyone to discuss the case around you. If you overhear people talking about the case, please remove yourself from that situation immediately. If someone approaches you and tries to discuss the trial with you, or if you see or hear anything about it, even accidentally, let my staff know immediately that you need to speak with me. You must not conduct any research, undertake any investigation, or otherwise obtain information about the case from an outside source. You must not read or listen to any news reports or internet information or other electronic sources about the trial. Your verdict must be based solely on the evidence presented in the courtroom and the law that I give you. Please do not talk to the parties, the attorneys, or the witnesses about anything. Please do not talk to any members of the media about anything. Please make sure you wear your juror badges at all times and that they are visible to those around you. Finally, it is important that you not form or express any opinion on the case until your deliberations at the end of the trial. You must keep an open mind throughout the trial. Now, folks, I want to emphasize that all of these admonishments will apply during the break. We're going to take a 10-minute break here. All of the admonishments apply. You may be tempted during your first break, official break, to want to talk about what just happened here. You must resist the temptation to talk about anything that just happened here. I encourage you to be friendly with each other. Talk about sports or current events or your job, your family. Don't talk about the proceedings. Don't talk about the case. Don't talk about anything that happens here in the courtroom. And these admonishments are extremely important. I know that I've mentioned that to you before, and I know that all of you smiled when I repeated it 3 times during your introductory session and must have thought that I was crazy. But that was my way of emphasizing to you how important these are. These are not admonishments that you could say, well, whatever, what's the big deal? I can just do this one little thing. No, you have to strictly comply with all of them, every single one of them. It would also be improper for you to think, well, who's going to find out? Who's going to know? Trust me, we will find out. So follow each and every single advisement, all right? Each and every one of you must do that. If you don't do that, it will create major problems for the case. By the way, before I break, I wanted to tell you that I've administered an oath to all my bailiffs. That's Ms. Robinson, Ms. Gerlings, and Ms. Zagel, to not permit any person to speak to you about this trial, to not speak to you themselves in relation to this trial, and to return with you at the end of each break as ordered by the court. All right, with that, let's take a break. Thank you, folks. If you would follow Ms. Zagel, Ms. Robinson, and Ms. Gerlings out of the courtroom through the side door, please. The record should reflect that the jurors have now exited the courtroom. Everyone may be seated. All right, folks, this is a short break, so let's have you back shortly after 1. Just a 10-minute break, please. All right, the court will be in recess.
Please rise.